I want to introduce our speaker, Mary Robinson, who most of you probably recognized, was the first woman president of Ireland and then the United Nations High Commissioner for Human Rights between 1997 and 2002. She was an academic, a legislator, and barrister, and a senior counsel in Ireland. And as such, and in her roles as President and High Commissioner, she has always sought to use law as an instrument of social change. And she's argued landmark cases before the European Court of Human Rights, as well as in the Irish courts and the European Court in Luxembourg. Now she's based in New York, where she is leading a project called Realizing Rights, the Ethical Globalization Initiative. She's a founding member and chair of the Council of Women World Leaders, and she recently, as you probably know, joined Nelson Mandela to found a group they call the Elders, leaders devoted to conflict resolution and the pursuit of justice in the global village. One of the things I want you to note as you listen to Mary Robinson is the extent to which she is imaginatively extending the idea of where rights should be enforced and where rights should extend. So she's at the leading edge of thinking about migration, she's the leading edge of thinking about children, she's the leading edge of thinking about the environment and the future. The conception of rights that she has is imaginative, creative, and clearly very important, and it's a delight to have her here. She is, of course, an adjunct professor here at SIBO when she has time to do it.
Thank you very much, Lisa, for those kind words. If I had an opportunity to discuss with you the introduction, we might have left out that bit about the elders. I still haven't got over the shock of being eligible. I feel I should come to this party dressed as an elder, whatever that is. But it is a pleasure to be back again. I did have an opportunity last year with a similar class, and it's nice for me to meet with you taking part in the conceptual foundations of international politics. As you've heard, I do teach a seminar next term where we link human rights and a fairer, more ethical globalization. But that's a small, very knowledgeable group who come together. And I'm also pleased, as I say, to have the opportunity of speaking to you, and we'll have our dialogue and Q&A afterwards, when you're still at a relatively early stage, the first few months of this course, which I'm told by one of my colleagues who was the class of 2003, Michelle Bologna, who's here in the front row, that this is the sort of rite of passage for students. So it's good that human rights is part of your thinking about not only the course itself, but what you may choose to study. So I hope that you will keep human rights clearly in mind as you go forward in tackling the wide range of possible concentrations which you will be able to choose from, such as international economic policy, economic and political development, international finance and banking, or international energy policy, and so on. My thesis is that human rights is relevant to every one of them, and that's what we're really going to look at and discuss in this class hour. And I must say that after many years of thinking about and working in international affairs and politics, in my capacity as President of Ireland for 7 years, and then as the UN High Commissioner for Human Rights for 5 years, and now working with my colleagues on linking human rights and globalization, I'm well aware that the connections, particularly with macroeconomics, with the wider political context, these connections are not well understood and very often, in fact, are denied. So we have a task to do. Let me begin by focusing my comments this afternoon on why it matters that the ideas of human rights and law exist in international relations. First, I'll approach these topics from a theoretical standpoint because I understand that will fit with the course that you are doing, the big theories of international relations. I'll then speak about the need for international law and human rights more generally. And then I'll draw on several examples of how the idea of rights has made or could have made a positive difference in very significant contexts, such as the world that we now know in this post-9/11 era and some of the events that have flowed from that. I plan to talk for approximately 40 to 45 minutes, and then I'd like to open the floor for our dialogue and conversation, which of course is the part that I enjoy much more, and I know there are mics that will go around so that you can place your comments or your questions. As I say, I know that you are looking at the main theories of international relations, often encapsulated in the idea of 3.5, realism, liberalism, idealism, and its offshoot, constructivism. Speaking generally, human rights aren't often considered to be a tenet of realism, which most often describes human rights as only, I emphasize, only a set of norms that isn't a significant force in the world, determined and dominated by the material force, the might of states. Liberal theory presents a different story. It emphasizes the gains to be had from international cooperation and from the influence of international institutions. Anne-Marie Slaughter, Dean of the Woodrow Wilson School of Public Policy at Princeton, points out that most liberals discuss human rights assuming the existence of a community of liberal, if you like, of like-minded liberal states that form a sphere of peace, democracy, and human rights. However, the behaviour of liberal states towards nations outside the circle, as well as the relations between states themselves, all outside the circle, are both markedly different. The main similarity between realism and liberalism is the state-centred approach of both theories. Human rights are most often placed under the constructivist rubric, that is, as a manifestation of the idea that world peace and stability arise from a consensus around shared values and norms. Under this theory, human rights are pointed to by some scholars as proof of the existence, or at least the emerging, of a world culture. I would think that values and norms sound a bit soft today, like a construct that isn't really useful in protecting individuals from terrorist attacks or the instability of any given state. But it's worth pointing out Jack Snyder's observation in a 2004 Foreign Policy magazine piece that the ideological underpinning of much of today's terrorism and war waging, ironically, seems to be, and I quote, to vindicate the constructivist theory's resurgence. That is, the relevance of a theory that emphasizes the role of ideologies, identities, persuasion, and transnational networks in understanding the post-9/11 world. As an example, what is known as the Bush Doctrine, and indeed Osama bin Laden's fatwas, are both heavily ideological. Again, State Secretary Condoleezza Rice has also identified the Bush Doctrine as being, and I quote her, an amalgam of practical realism and Wilsonian liberal theory. I say this to illustrate the fact that rarely does a given policy or action embody just one theory of international relations. This is certainly the case with human rights. I would argue that the world came together after the Second World War to craft a universal declaration of human rights out of respect for the dignity of each human being. Remember Article 1, all human beings are born free and equal in dignity and rights. And that the other motivation was that this was the foundation of national and international peace. The memory at that time, the fresh memory, was of 2 world wars, of a Holocaust, of the dropping of nuclear bombs on citizens in Japan, and indeed the start of the Cold War. And the massive loss of life from that war was very fresh in people's memories. And there was a very liberal and at the same time constructivist idea looking forward about how the world should be. There was a need to craft something to protect against the purely realist ways of state interaction. And the result was the beginnings, the root of modern international human rights law and the architecture that has flowed from it. I asked you to read some of the chapters from a book about Eleanor Roosevelt and the crafting of the Universal Declaration to make it as broad as the world of 1948 would allow, with lawyers from China, from the Lebanon, from Chile, from France, from Canada, working under Eleanor Roosevelt, who wasn't herself a lawyer, but who was of the age and had the disposition to be able to be very bossy and to be able to boss the lawyers to write the Universal Declaration in language that would be understood. And this was the strength of the Universal Declaration, that it looked to the great religions in the world at that time and drew from them, that it didn't just talk about rights, but also in Article 29 reminded people that everyone has duties to the community, without which you don't reach the full expression of your personality. So that sense of a link between asserting rights and protecting rights, including the rights of others, but also having duties to the community. But what happened afterwards? That was in December the 10th of 1948. And then afterwards, the Cold War deepened, and geopolitical forces mandated the splitting of the Universal Declaration of Human Rights into two human rights covenants, one of which would deal with civil and political rights and was very strongly endorsed by Western countries and in particular, obviously, by the United States. And the other covenant dealing with economic, social and cultural rights, rights to food and safe water, health, education, shelter. And in this battle of ideologies, the Soviet bloc and many developing countries said that they would first build their economies and try to strengthen access to health and education before they would open up to greater political participation if they were prepared to open up at all. And so, as you read, it was the international and domestic realities and ideologies of states that gave rise to the sharp divide between the Soviets and their allies, who were only too willing to endorse economic, social and cultural rights, and the United States and Western Europe, who were willing to endorse primarily only civil and political rights. And there is a reason why the United States in particular resisted the idea that economic and social rights were rights, as opposed to political aspirations. And this stemmed from the pre-civil rights amendments in the United States, which had an economically and politically disenfranchised African American population in the South. And it didn't want that population to be legally bound or they themselves to be legally bound to that population, to raising the living standards to match those of the white population. The Soviets themselves were living in a communist state where civil and political rights, emphasizing the individual, didn't meet the communist goals and were not part of the accepted system. And so, while human rights are often conceptualized by their modern detractors as soft, they were perceived as anything but soft in the halls of power at the time that they were first presented as a central element of international law. Still, it's true that it remains a strategy of many nation-states that they don't want to be bound by international law that what they do is they spin human rights as soft and possibly as divorced from state security in order to evade accountability for the measures that they may have ratified as treaties. So this brings me to my next point about international law and international human rights law in particular, and one I hope we'll have some time to discuss, and that is enforceability. Most realists will tell you that international law just simply, in real terms, doesn't matter, because it couldn't constrain states or their behaviour, for example, in waging World War I or indeed World War II. And both the Kellogg-Briand Pact and the League of Nations were in existence at that time and proved to be ineffectual. As Chandra Lekra asserted in a recent article in the Journal of International Affairs, and I quote her, "States would never create laws that constrain them against their own interests, nor would they continue to conform to any law that had once served their interests when it ceased to do so. In short, law is at its best phenomenal, and you would be able to pronounce that, in international politics. At worst, reliance upon laws is naive, even dangerous, in an anarchic international system, in which states' uppermost priority must always be survival. Thus, the disciplinary divide between international law and international relations has emerged." This comment of Chandra Lekra Sriram echoes the sentiments of John Austin, whose questioning of the existence of international law has been haunting the field since the mid-19th century. I do believe that somebody very well known here in Columbia University and a very good friend of mine, Professor Lou Henkin, posited the best answer to Austin's query to whether or not international law exists almost 3 decades ago, when he noticed that, and I quote him, almost all nations observe almost all principles of international law and almost all their obligations almost all of the time. So in practice, the system is much more accepted than is often realized. If you allow me to paraphrase the seminal work of Lou Henkin, How Nations Obey, he reminds us that many of the core concepts in international relations today, for example, sovereignty, non-intervention, and immunity, were developed through interstate relations and then codified into international law. International law is the normative system of standard setting and the standard currency of international relations. Much of the talk among leaders in the world today about democracy building is impossible without reference to international law. And so the question before us is not whether international law exists, but rather, how does it work? How does it function? And to what end or ends? To begin to answer this question, it's helpful to turn to another of the authors I assigned to you, my friend Harold Coe, who is now Dean of the Yale Law School, but when I was serving as UN High Commissioner, he for a time was the Undersecretary for Labour and Human Rights under the Clinton administration. His fundamental stance is that international law and international politics are not just state-centric anymore. His view is that we live in a globalized world in which, and I quote him, in which various actors, states, judges, non-governmental organizations, international institutions, and corporations interact to make, interpret, enforce, and ultimately internalize rules of international law. International law is thus not something that's imposed in a top-down hierarchical fashion, but a set of rules that disseminate interactions among a variety of actors within and across borders. This approach to international law diverges significantly from traditional state-centric approaches in the multiplicity of actors that might be engaged in the creation and interpretation of legal obligations. So Coe, in effect, tells us that law is no longer the sole province of the state. Or in other words, to equate law only with sanctions is to approach law in a way that's no longer helpful in our current context. The rise of non-state actors, whether terrorist groups such as Al-Qaeda or multinational business, with economies often larger than some states and making efforts to address the extent of their obligations under international law, also proves this to be true. It also shows us that international relations are no longer, as I said, the sole province of the nation-state. I recall the way in which the attempt to have a landmines convention was stalled in the United Nations because certain countries, including a certain large country that we're in, didn't want to have a landmines convention. And a hugely robust and energized coalition of some governments, Canada playing a very strong role in this, and many NGOs, a whole coalition worldwide, got together, and there were various images that made a difference. Princess Diana going to Angola and being photographed, walking through a minefield and so on. But in fact, it was an energizing of a wide public opinion, the media played a role, etc. And we got a landmines convention, which has saved many hundreds of thousands of lives and led to the mines that had been placed now being slowly and painfully removed. Another short piece I assigned for you to read was from Nick Cowan, the Secretary General of the International Commission of Jurists, in which he verifies that, and I quote, large corporations are beginning to challenge the traditional economic and political dominance of governments, and governments are losing authority up to international organisation bodies, and internally, as state functions are to a greater extent privatised. Nick Cowan also believes human rights must provide the clear, binding global rules of contact and accountability we need as we move forward in this age of globalization, as they are, and I quote, the only existing and internationally agreed upon expression of minimum conditions we all should enjoy if we're to live in dignity as human beings in our world. So part of the work we do in realizing rights is working increasingly with the private sector with business to identify the appropriate responsibility of multinational corporations and how they use their sphere of influence, not displacing the responsibility of governments to protect and promote human rights of their citizens, but because they have such power, and because the power of those states is less, given the privatization of all kinds of services, not just education and health, but prison services, military roles in protection, etc., as we see currently at the moment in Iraq. But given this more nebulous structure of actors and politics in which we now live, it's important to ask, is international law still relevant to the operation of nation-states? I would argue that yes, it is. At the most general and sometimes invisible level, international law regulates the world's telephone lines so that you can, you who are international students can call your families, that your mobile phone will work. It regulates the world's postal systems so that snail mail can operate and letters posted in Europe can arrive here or arrive in South America within a reasonable amount of time. It regulates the world's oceans and the airways for commerce and for travel. And it also needs to regulate the behaviour of states and citizens. As Nick Howan again emphasises, and I quote him, international law is not a substitute for effective national law and policies. But international standards do help to provide common guidance to states, to harmonise rules at time of weak national regulation. International rules set minimum standards as benchmarks, and international laws need to step in where national law is absent or without peace. In fairness to its critics, I think we must acknowledge that international human rights law is not perfect. It's an imperfect system. As Kofi Annan has said, too often international law is applied selectively and enforced arbitrarily. It lacks the teeth that turn a body of laws into a consistently effective legal system. And yet it's also young. International human rights has not been around for that long. The root of it, as I mentioned, is the Universal Declaration of Human Rights. And starting on the 10th of December this year, we will mark the 60th anniversary. 60, believe me, is not such a great age. There is life after 60, and I'll come back to that 60th anniversary and how we might use it. And it's interesting that the world actually began this short century, the 21st century, very well for human rights. I was serving in the United Nations at the time, and I remember being very heartened that there was a shared sense of the importance of the international legal framework that had been built up over a half a century, and that the first meeting of the General Assembly in September 2000 would emphasise the vital role of international human rights and rule of law in an increasingly interdependent world. Government leaders, the head of nation states, expressed the international community's renewed commitment to the principles of justice and international law through the signing of the United Nations Millennium Declaration. During that special 3-day session of the General Assembly in September 2000, a total of 273 new treaty actions took place, meaning governments either signed or ratified or took positive steps in relation to existing treaties, changed their position positively and made a commitment. 187 signatures and 86 ratifications or accessions on instruments such as the optional protocol to the Convention on the Rights of the Child, on the involvement of children in armed conflict, the Convention on the Elimination of All Forms of Discrimination Against Women, the Rome Statute of the International Criminal Court, and the International Convention for the Suppression of the Financing of Terrorism. You've been encouraged to read the Millennium Declaration. It's interesting just to see that 6 short years ago, the world framed tackling poverty in very strong human rights terms. It was a moment of rededication to international law and institutions as the best hope for the 21st century. And it's worth mentioning that during the UN Millennium Assembly, the largest ever opinion poll in the world at the time was carried out. The results showed that an overwhelming majority of people from all parts of the world identified the need for greater protection of human rights as their top priority in the 21st century. And I think it's important that people at that time were very much drawing the conclusion that a world increasingly connected by a web of technology, information, transportation and commerce must also be connected by shared values and shared norms. A world without international law, then, would be, to employ the language of the realists, much more anarchistic than the world in which we currently live. It would be a world where citizens have much less ability to hold their governments accountable for their rights. Instead, just over the last 15 years, we've seen a number of measures, and I'll just remind us of them so we see the building blocks of human rights. The establishment of criminal tribunals for the atrocities committed in Rwanda and the former Yugoslavia, and the first post-Nuremberg indictment of a former head of state in the Milosevic case, and now also Charles Taylor, the former president of Liberia, is awaiting trial. General Pinochet was held accountable for the crimes he committed against the Chilean people under the Nuremberg principle of non-immunity for international crimes committed by someone while still a head of state. The adoption of the UN Security Council resolutions that protect women and children in armed conflict. The criminalisation of rape as a crime against humanity in the context of war. And the ratification of the Rome Statute and the creation of the International Criminal Court. And let me also draw on experience of a way in which I was able to observe that civil society groups were using the commitments governments had made to find a process that would hold them accountable. Not going into court, even an international tribunal, but actually working as civil society to hold the government accountable. I remember that Brazil, and I just take this as an example because lots of countries didn't compile their reports as they had undertaken to do under the international human rights system. And so by singling out Brazil, it's more that it was a very good way to observe how Brazilian civil society was going to hold Brazil accountable. What happened was that Brazil was in delay, had not in time submitted a report as it was bound to do under the International Covenant on Economic, Social and Cultural Rights. And a wide group of civil society from São Paulo, Brasilia, Rio de Janeiro got together, linked on the internet, and drew up an alternative report on economic, social and cultural rights for Brazil from a civil society perspective. And then about 11 of them came to Geneva. I met them as High Commissioner, and they went along at lunchtime to the members of the Committee on Economic, Social and Cultural Rights. And the President of the Committee explained that it would not be possible to give them a formal hearing, because that was for governments. But they were praised by the President of the Committee and the other members for this work, because that would make it much easier to persuade the Brazilian government to compile its government report, which would allow the civil society to differ in some respects and maybe put in an alternative report to a parallel report to that government report. And as it happened, 2 weeks later, I was making an official visit as High Commissioner to Brazil. So I land with the heavy report of the civil society groups under my arm, and in front of the media, I say, I'm going to ask the Brazilian government, where is the government's report? And this became quite an issue, and civil society got a great boost of attention to their alternative report. And then the then Minister for Human Rights, he was Minister of State for Human Rights, said, well, we agree that we shouldn't be in delay, and we will now give it priority and produce a government report. And it's interesting that the then Minister was the current Special Rapporteur on Human Rights who is visiting Myanmar on behalf of the United Nations, a distinguished human rights advocate, Paulo Sergio Pinheiro. He was kept out of Myanmar for 3 years, but yesterday he was getting back in for the first time and is going to try to address the question of how many are in prison, how many were killed during the recent disturbances, during the recent conflict there, etc. But it was he who made a commitment, and we had a discussion that it wasn't sufficient for the government belatedly to bring in its report, that it should engage with these women's groups, poverty groups, those who were fighting the landless groups, etc. in Brazil, and work together. And if there was difference, the civil society groups could put in a parallel report. And several months later, Paulo Sergio Pinheiro told me that this was a real bridge that was created between his ministry and other government ministers and these civil society groups. So it was a process that held to accountability in a more political way, and was determined that there had to be accountability, but it wasn't a matter of going to court in a more traditional way. Obviously, we can't have a complete discussion about the centrality of human rights and international law in international relations without noting the impact of the terrible attacks in this country of September the 11th, 2001, which obviously shook the United States and the world. Since that day, the commitments that I mentioned that were made by nation states at the start of the new century have, I believe, been overshadowed by the threats of terrorism, by fears and uncertainties about the future, and by questions about the viability of a network of open societies joined by norms and values. The whole approach of characterizing the response as a war on terrorism has made the sidelining of human rights and indeed the dipping of standards on issues like torture seem more acceptable. I say seem because the price is extremely high. It doesn't work and it undermines extremely important standards. I've spent the last 18 months as part of a team called the Eminent Jurist Panel of the International Commission of Jurists, having hearings in about 20 countries, including the United States. And last year, on the 5th anniversary of 9/11, we had a hearing in Washington. I've also been in Moscow. My colleagues have been in different parts of the world, in Africa, in Asia, in the United Kingdom, in Belfast, and so on. And we issued press releases and accounts of what we found, but really what we are trying to do is assess the trends, assess how serious the aftermath has been and the knock-on effect of standards being dipped, and we will be reporting on that early in the year. Obviously, the fact that the United States has not fully upheld international standards, such as the Convention Against Torture and the Geneva Conventions, has had a negative impact because some countries have tried to explain that there is now that the standards have changed, and it's been important to assert the standards have not changed, even if they are not being upheld in the way that they should be upheld. And the final point I want to make about international human rights in practice is to recognise that if a more secure and peaceful world is the end goal of international law and the primary goal of theories of international relations, then we must remember that 9/11 didn't in fact change much in the lives of most people on the planet. Human insecurity was already a daily reality before 9/11 for the hundreds of millions who live in absolute poverty or in zones of conflict, and it remains so. For these people, insecurity isn't equated with where a terrorist may strike, but instead with where tomorrow's only meal may come from, or how a decent job can be found when you've got 80% unemployment that will provide enough income to buy life-saving medicines, maybe for a dying child. For women, gender is itself a risk factor threatening their security. The secret violence of household abuse, the private oppressions of lack of property or inheritance rights, the lifelong deprivations that go with a lack of schooling, and the structural problem of political exclusion. In other words, the comprehensive insecurity of the powerless. And this is, I think, where we have a challenge that we may want to discuss a little bit. The Millennium Declaration was a commitment framed in human rights terms to tackle these divides of poverty. And then the sidelining of human rights after the terrible attacks on 9/11 also helped to open up an ideological divide. And we see this reflected in many parts of the world, the divides on religious grounds, the ideological divides, the sense of an opening rift between countries. And I come back then to conclude my remarks and open up our discussion to the Universal Declaration of Human Rights. When I was serving as UN High Commissioner, I started in September 1997 and found that there was a small unit in the office in Geneva working on the 50th anniversary of the Universal Declaration. And I asked them, how are you going about that? How do you plan the 50th anniversary? And they said, well, the first thing we've done was look at how they planned the 40th anniversary. And I discovered that Peter Gabriel had a whole series of concerts about human rights, and other things had happened for the 40th anniversary. And then we planned to do it on a wider scale, and there were lots of invitations to speak, and we tried to raise certain issues and put more emphasis actually on economic and social rights during that 50th anniversary year. But the truth is, when we think about it, there is no similar comparison between now, as we are about to mark the 60th anniversary, and how the 50th anniversary was marked. It's not worth looking back. It's as if it was a completely different world. And we can be conscious of one very negative problem that I've talked about, the impact of the attacks of 9/11, the focus on security, on war on terrorism, and the undermining of standards that had been held very firmly up to then, ambivalence on torture, holding of people indefinitely, Guantanamo Bay, etc. But there's also a very positive potential, and that is the huge rise in communications. Our world of 2007 going into the 60th anniversary year can communicate like never before. And the elders, this body that I somehow have been told I'm eligible for, have decided to have a kind of gentle framing of what we hope will be a very wide recommittal to the Universal Declaration of Human Rights. If you read it, and there are many, many language versions on the Office of High Commissioner for Human Rights. I know that because while I was still serving as High Commissioner, I got the Guinness Book of Records for the most translated document in the world. It's short, it's 30 articles, and the General Assembly, when it was adopted in Paris, said that they called upon every individual and every organ of society, bearing this declaration constantly in mind, by teaching and education, shall promote the protection of the rights and freedoms contained therein. So it wasn't primarily a matter only for governments. It was a little like Harold Cole sees the interactions of international law, the many actors who must take part, individuals, students, those who are teaching here in Columbia and elsewhere, the private sector. I was talking this morning to the leader of a very large company about the potential for his company to post on the website, to make sure that every employee was aware of the Universal Declaration, but also to look at the supply chain and see whether there was exploitative conditions of work, child labour, forced labour of any kind, to see whether the environmental concerns were being addressed, and so on. And if we think about it, the world that I described in 1948 was very fearful and anxious. What about our world today in similar terms? We have many of the same problems. We have nuclear proliferation, not only very much as a matter of concern, but also potentially linked to a dirty bomb problem that is a new form of potential terrorism and fear. We have the ideological divides that I mentioned, and we have the challenges and the potential catastrophic impact of climate change. And in that sense, if we're to address these challenges, we need those common values. The world needs to be reminded that every government in the world, every government accepts the Universal Declaration of Human Rights. Implementation and enforcement are another matter, but it's not disputed. And they are the rights and the birthright of individuals. So I think we can see human rights as being a huge potential exercise of soft power. If we can use the Universal Declaration to recenter human rights where they were at the beginning of this century, maybe this will have huge impacts on how we address climate change, how we address the Millennium Development Goals, how we move forward. So in that sense, I think both international human rights and international law generally have a huge power to influence our world. And that's really what I'd like to discuss with you now. So the floor is open to whoever wants to take the challenge. Thank you.